Essentially, you cannot take somebody out of a race because an opponent would like to have it that way. While most states were thrilled to have me, there were some that didn't, and they didn't want that for political reasons.
The twice impeached, 4 times indicted, adjudicated sexual assaulter, and apparently deep in his basement, former president, earlier today, responding to the Supreme Court's decision that states don't have the authority to kick him off the 2024 ballot, claiming that states that challenge his eligibility only did so for political reasons. Well, joining me now to respond to that is Janae Nelson, president and director counsel of the Legal Defense Fund, who wrote an amicus brief urging the Supreme Court to enforce the 14th Amendment, and Krista Kafer, a lead plaintiff in the Colorado case, who voted for Trump in 2020. Thank you both for being here. Krista Kafer, I want to go to you first. The former president, Donald Trump, and I hope he's okay because he appears to be locked in his basement, said that this was brought by Joe Biden, was brought by President Biden for political reasons. But you're a named plaintiff on the case, and my understanding is all of you are Republicans or independents. Am I right about that?
Exactly. We're all independents or Republicans, in fact, more Republicans than not. And we were concerned about somebody who fomented insurrection in an attempt to overturn an election and disenfranchise 80 million people. We know that it is very clear under the 14th Amendment that if you've taken an oath of office and that you attempt to subvert that oath, foment violence, foment insurrection, you do not get to run again. We're very disappointed that the court has seen otherwise.
What do you make of the argument by the court? And it was unanimous in this sense. They disagreed on other things, but all 9 seem to agree that you can't allow a state to enforce Section 3 because each state might enforce it differently based on different criteria. And so you'd have sort of chaos if each state could decide whether somebody had violated Section 3 or not. What do you think of that conclusion?
I'm not unsympathetic. I know it would be disruptive. But the fact is that if we do not enforce the Constitution, if we keep an insurrectionist on the ballot, that's not disruptive, that's dangerous. And in the past, this particular court has not been particularly concerned with outcomes. Many of them see themselves as originalists, meaning you apply the law no matter what. You don't concern yourself with the outcome. Now, all of a sudden, they're living constitutionalists, and they're concerned about the outcome, not the law. The writers of the 14th Amendment, they'd already seen what insurrectionists could do to a country. They put this in there for our protection, and now they've essentially rendered it moot by saying only Congress can make that determination.
Wow. I mean, Janae, let me go to you on that, because, right, it's like, I don't remember. I read the Dobbs decision, which I have to say, the 3 dissenting concurrence ladies, they quoted Dobbs out of the gate. And the point being that Dobbs created utter chaos. Women have died as a result of Dobbs. No one knows whether you can be arrested in one state, not arrested in others. Can you leave your state if you want to get an abortion? They weren't concerned about the chaos. And then for you specifically, the Legal Defense Fund is litigating. We have a map here of how many states you all are litigating questions about access to the ballot, questions about redistricting, questions about the right to vote. That's how many states. You can see it. It's most of the states have an up-in-the-air question about access to the ballot. What do you make of the majority, the conservative majority, now saying, "Oh my God, we're concerned about chaos and the things happening differently in different states"?
You know, there are two matters, Joy, that really are irksome about this decision. Two actually is too limiting. There are many more, but let me just point to 2. One is that our system of elections differs state to state always in any manner of way. You might be able to use a voter ID in one state and not in another state. You might be able to vote by mail in certain ways in one state and not in another state. We're used to having a patchwork. That's not new. That's actually our election system, and it's been our election system for our entire existence. So that's just number one. But I think what I find most concerning, and it's such a sad irony, is that this court is saying that Congress can enforce the 14th Amendment and enact legislation to protect against the vote, right, against voter disenfranchisement in the Voting Rights Act. I just came back from Selma this weekend, where people who were violently disenfranchised took to a bridge to peacefully march to ask for their constitutional rights, compared to people who stormed the Capitol and wreaked havoc on our nation and threatened the lives of elected officials. And there's a protection for those individuals, but not protection for the marchers who try to make our entire democracy fair for everyone. So this court is saying that Congress can enact legislation in this particular way if it wants to protect against insurrection. And it has a situation where Congress acted pursuant to clear authority, and they actually gutted the Voting Rights Act over 10 years ago, which opened the door to much of this havoc. So the hypocrisy is not lost on me.
No, you're absolutely right. I mean, that was the enabling legislation for the 13th, 14th, and 15th Amendments. The enabling legislation was the Voting Rights Act, and it's getting violated, and they keep on undercutting it and saying, no, we don't need the Voting Rights Act. That's not important. So they don't even respect the enabling legislation when it is actually passed. I'm going to give you the last word on this, Krista, because what do you want to see happen now? I mean, you are a Republican voter. They're saying your primary ballot must include someone who you, as even a Republican who voted for him, view as an insurrectionist. Because it seems to me that in this case, I'm not sure why Arnold Schwarzenegger doesn't just run for president, put himself on a ballot and litigate it and say that's not self-executing either because I wasn't born here. Or why doesn't a 12-year-old, a little brilliant 12-year-old go on the ballot and say it's not self-executing for this either, for the age piece. Like none of it is self-executing. For you, what do you want to see happen now?
I couldn't agree more. I mean, actually, I think that George W. Bush or Barack Obama would be better than either the two candidates that we'll see this fall, but they can't under the Constitution, and we know it's self-executing. And so since the court did not do its duty, and Congress also didn't do its duty during the impeachment trial to keep an insurrectionist off the ballot, it is now time for the people to act and make sure that we have someone in office who has not fomented violence in order to stop the peaceful transfer of power.
Janae Nelson and Krista Kafer. Janae, you're a friend of the show. We know we're going to have you back. But Krista, I just want to let you know the door is open, my good sister. You can come back anytime. You're making Colorado look good and smart. I love it. Thank you so much for being here. It is so wonderful to see a rational Republican who is still existing. Yes, makes us very happy. Thank you very much. And coming up next, thank you.
More than us than we know.
Thank you. We'll holler.